Appeals. My name is Gilbert Roman, and I'll be presiding today. To my right is Judge David Furman. To my left is Judge Nancy Lichtenstein. We have two cases on the docket. The first case is People v. Smith, 17CA1450, and it looks like counsel are here and are set up and ready to go. And I know you're experienced counsel, but I'll ask anyway, do either of you have any questions or concerns about the setup that we should know about the procedure? All right, and then the second case is Park Forest Care versus Westminster, 17CA1503. Our counsel here and ready to go for that case as well. Very good, all right. And I can chat with you a little more when we have you set up then. So if you have any questions or concerns, keep them in mind and be sure to let me know if I don't bring it up before you begin, all right? All right, so let me remind everybody then that this is being taped live, or right now it's live, so, and then it will go into the archives where others can see it later. So if you have anything of a sensitive nature in the case that, or any a name that should not be revealed, please keep that in mind, and that goes for the second case as well. I also want to remind everybody that if you have anything that will make noise, your phones specifically, please turn those off at this time because they become very distracting, all right? With that, I think we are ready for the first case. So I will call People v. Smith.
Good afternoon. My name is Amy Trenery, registration number 46148, and I represent Willard Smith. I'd like to just jump into the questions that the court submitted in its order last week to be answered during oral argument. And the first question was whether this claim should be recognized as a sentence imposed with jurisdiction as opposed to a sentence that was imposed in an illegal manner. To begin with, I want to clarify that Mr. Smith's claim is and always was a jurisdictional claim, and specifically that failure to advise him at his first appearance, according to 1611-206, 1607-207, and the related procedural rules of Crim P5 and 32F, divested the district court of jurisdiction to proceed any further, to make any decisions on his probation revocation, and to eventually resentence him. And this claim derives from the mandatory language of those advisement statutes and rules. They are phrased in terms of the district court's duty and what the court shall do, not just advise the defendant of the nature of the claims against him and the potential penalties, but also ensure that he understands that. There has to be some consequence for failing to abide by that mandatory language, and Mr. Smith's position is that the consequence is a lack of jurisdiction to proceed.
Ms. Trenery, I understand that your argument is a defect in an advisement. Do you have any legal authority that would state that a defect in an advisement is a jurisdictional issue?
Not in so many words. I haven't seen a case that in Colorado that describes it in those terms. The case that I did find while I was preparing for oral argument is the Munoz case, M-U-N-I-Z, and it's at 667 P. 2nd, 1377, a Colorado Supreme Court case from 1983. And this, it was a case that the defendant had already served the entire sentence and raised a 35C claim in that case, so slightly different. But the claim was that he hadn't been properly advised before he pleaded guilty. Again, slightly different. This was a Rule 11 case, not a Rule 5 and 32 case.
Ms. Trenery, sorry to interrupt. As you're talking, and as I was reading your briefs, when you're talking about improper advisement or something along that line, that sounds like an illegal manner type of a claim instead of a jurisdictional one. So could you respond to that?
Sure. I'll start by referencing the Bowerman case that was cited in the reply brief at page 8. And in Bowerman, this court adopted the definition of an illegal manner from the Colorado Practice Series. And to quote it, it says, an illegal manner a court imposes a sentence in an illegal manner when it, quote, ignores essential procedural rights or statutory considerations in forming the sentence. I think that word forming is what makes this case different. The Bowerman case provides some examples, sort of a case survey of illegal manner claims, and they include failure to allow the defendant an opportunity for allocution, failure to consider the statutory factors, failure to complete required testing, or as in Bowerman, the claim that the restitution amount exceeded what was named in the information. Those claims all are relevant to the district court judge's choice of sentences procedurally. So that's where I go back to forming the sentence. Those are factors that could advise the court or sort of form the decision for exactly which sentence to impose. Here, there was no decision about which sentence to impose. This was a stipulated sentence according to an agreement with the prosecution. So of course the district court did have to choose whether to accept that or not. But those types of procedural requirements weren't relevant to forming the sentence. And that's why I see it as backing up to the jurisdictional issue, beginning with the initial advisement and carrying through to the case, because if you do look at the transcripts of what happened after that initial appearance, which was on October 12th, 2004, we don't have a record except for the changed minute order as to what happened there. We don't have a transcript to confirm what Mr. Smith says there. After that, he appeared with his first court-appointed attorney, Mr. Culver, who waived further advisement. And then after that, the next proceeding was the revocation hearing, where he changed counsel at the beginning of the hearing. And the only thing that was asked as to whether he was advised was, I assume you went over this, but the district court judge didn't ask a question to confirm whether that had in fact happened. And this was to the lawyer who had just been appointed literally minutes before this, who was Mr. Smith's lawyer in his related case, the 2004 case.
Excuse me, based on the facts that you're telling us, can you tell us why that's not a 35C claim?
I mean, there is an argument, especially under Munoz, that should have been raised under 35C. I don't think it's an illegal manner claim, though. If you look at the language in the Munoz case, eventually the court decides that if the record doesn't show compliance with the advisement rule, that the judgment or sentence entered, quote, is void. And I think that voidness is somewhat similar to a lack of jurisdiction. You could say that the sentence entered was void because the court didn't have jurisdiction to enter it because it didn't follow the advisement requirements, not just to provide the advisement, but to ensure that Mr. Smith understood what he was admitting when he admitted to violating his probation.
So I take it you would agree that if it is a 35C, that it's time barred?
Well, he would have the opportunity to demonstrate justifiable excuse or excusable neglect, which is something that wasn't litigated in this case. So if the court does decide that this is a 35C claim rather than a 35A jurisdictional claim, I would submit that the proper remedy would be a remand to litigate justifiable excuse or excusable neglect. There's another sort of procedural twist that happened as well that's not entirely clear from the briefs that I also wanted to mention. When Mr. Smith, at the revocation hearing, admitted to violating his probation, there was no specification of which terms he was admitting to. And so he had been, the complaints include 5 violations of 5 different terms. There was an initial complaint that alleged that he had violated 4 different terms, and then a supplemental claim, or amended complaint that alleged that he violated the first term, which was not to commit a crime while he was on probation. And then once he was charged with his 2004 case, that amended probation violation complaint was filed. That was after the initial advisement. That was after he appeared with Mr. Culver and waived further reading. So really there's no indication whatsoever that Mr. Smith was ever advised that he was admitting to committing a crime while he was on probation, which is ultimately what caught up with him in the other case, because his sentence was enhanced based on his having been on probation. And also, there's some an indication in the 35C transcript from the sort of original post-conviction proceeding where it's not the evidentiary hearing, but a motions hearing that happened before that, where Mr. Smith's counsel explains that a probation officer testified in his 2004 case. So there was some substantive spillover between the two cases.
Can you speak to the second question that was sent, the present need doctrine, and what its
Yes.
status is today?
So my understanding of the question is that, Wiedemer at footnote 19 discusses the intersection of the present need doctrine after the enactment of section 16.5402 and the Fagerholm case, which sort of put a 5-year grace period onto the new statute. In short, I think that Wiedemann, the footnote demonstrates that the present need doctrine coexists with the statute of limitations statute. At the end of the footnote, Wiedemer actually applies the present need doctrine and said that present need is demonstrated by virtue of the statute and the Fagerholm decision itself. So that shows us that they both could arguably apply depending on the circumstances. But backing up, if this is a 35A claim, the statute 16.5402 simply doesn't apply. The statute's plain language in the title and all of the language used throughout the statute applies those limitations only to collateral tax on a judgment, not on a sentence. And so a pure sentencing claim doesn't seem to be covered by the statute of limitations contained in that statute, which makes sense because 35A has its own time limitations. For an illegal manner claim, it's the 120 or 126 days. But for the other two types of claim, those can be raised at any time. So at least arguably, the statute doesn't apply. One division of this court, the Graham case, which is cited in the reply at pages 1 and 2, decided that the present need doctrine does apply to sentencing claims, but that holding sort of conflicts with the plain language of 35A, which says these claims can be brought at any time. So of course, this panel is free to disagree with the Graham decision. The second part of the question about present need, I see it as sort of two questions, is how does it apply to this case? Aside from possibly not applying at all, if this division disagrees with Graham, my first position is that it was waived by failure to raise it in the district court. The prosecution's reply, which is at pages 436 through 41 of the court file, never mentions lack of present need, never mentions mootness, and never mentions the fact that Mr. Smith has already completed his sentence. Likewise, at the 35A hearing on February 17th, 2017, the prosecution never raised any arguments relating to present need or mootness or anything of that sort. Similarly, the district court's order doesn't address present need. It really just goes to the substance of the claims. It's a little bit confusing when it comes to the holding, I'll admit that. But Judge Schifferl, who presided over both this case and the 2004 case throughout their entire duration, didn't raise that on his own. He's probably the person who knows the most about the cases, perhaps aside from Mr. Smith himself. And he didn't seem to have any concern about whether there was present need or question the relationship between the two cases. And so if you look at Moland on pages 140 to 141, that's where there is the authority that requires the prosecution to raise present need at the district court level or it's deemed waived. And here, I think that the facts sort of give us a good illustration of why that's the rule. Mr. Smith did set forth the facts demonstrating present need in his petition, his 35A petition, and his supplemental filing that he filed after the hearing. There also is that description in the 35C hearing, which is on 22914 at pages 4 through 5, where his attorney explained the relationship between the two cases a little bit more. If there are facts that this court would like to know that are not explained by that limited explanation, factual development should have happened at the district court. So again, if the court feels like there is an inadequate demonstration of present need on the current record, I believe that the remedy would be to remand to further litigate that issue. I'd like to save the remainder of my time for rebuttal. Thank you.
You have 1 minute, 45 seconds for rebuttal time.
Good afternoon. May it please the court. My name is Joseph Michaels, attorney registration number 40403. I'm here today on behalf of the people of the state of Colorado. I'd like to start today by responding directly to this court's questions, but before I do, I think there is an overarching consideration that is worth keeping in mind as this court assesses this case. And that is, in the opening brief, there was never one mention throughout of an impact on this other murder conviction. And so when I was drafting the answer brief, I never had the benefit of understanding or responding to an allegation that there was an impact on another murder conviction. That said, I think there is sufficient information in the briefing as it stands to address the arguments and reject the defendant's contentions on appeal. And I'll start, I think, with the first question that this court sent out, which is the defendant's motion properly cognizable as a claim that the sentence was imposed without jurisdiction, or is a claim that a sentence was imposed in an illegal manner? And it would not surprise this court to recognize that I am contending that it is an illegal manner type of claim. And I would start by saying that there was in no way, shape, or form was this court without a subject matter jurisdiction to address the probation revocation hearing, to address the merits of that complaint, or to hear the ultimate guilty plea to that complaint. Now, opposing counsel has conceded both today and in briefing that there is no law in the state of Colorado that says a faulty advisement strips a court of jurisdiction, and I can confirm that I have found none. On the contrary, this court has assessed faulty advisements as a general matter, not specifically as to initial advisements, but has assessed faulty advisements to see the impact on the defendant's constitutional rights. So, for example, the right to plead guilty, the right to a jury trial, or the right to waive jury trial, or the right to testify on a defendant's own behalf. That's all assessed for whether, if there's a faulty advisement, the court still looks to whether the defendant's actions was knowing, voluntary, and intelligent to reach a constitutionally valid guilty plea. Here, we're not even talking about the constitutional aspect, we're talking about a statutory mandate. And the statute, by its own terms, explicitly tells us what the outcome will be. And if this court would humor me for a second, I'll read you that statute to better express, I think, what the remedy is. And so as opposing counsel noted in the opening brief, the revocation statute 1611-206 specifically cross-references a court's duties for an initial appearance and initial advisement. And in section 16.7.207 sub 1, it talks about what those requirements are. Notice to the defendant essentially is the crux of that. But section 2 specifically says what occurs if it's not fully complied with. And the idea behind this notice to the defendant is the court shall not accept a plea of guilty, that's essentially what we are dealing with here, a plea of guilty, or no contest, without first determining that the defendant is advised of all the matters set forth. Well, here, as a matter of substance, we know the defendant was advised of all the matters set forth in 16.7.207 and the attendant 16.11.206, specifically the nature of the charges against the defendant, because the defendant was advised in open court, which means that the court went through essentially the Rule 11 advisement for pleading guilty, and was advised that it was a probation revocation, and the court had to ascertain that that guilty plea was knowing, voluntary, and intelligent. So we know, as a matter of record, that the defendant executed a constitutionally valid waiver when he pleaded guilty, and that then satisfies 16.7.206. 7, sub 1 and sub 2.
Let me follow up on that, because I think you said the record stated that he was advised of a probation revocation, and his contention all along was that he was advised of a TRO. So can you address that?
So there are two parts to that question, and I'll try to remember to get back to the second part after I answer the first. The first is he was advised at the initial hearing of allegedly of the TRO, but he didn't plead guilty at that time. He pled guilty later on when he was then advised, and he pled guilty based on those elements. And so that subsequent guilty plea, along with that subsequent guilty plea basically cured any notice deficiency. So any error in that initial advisement, and I think it was October of 2003, was severed and rectified when he pled guilty to the probation revocation subsequently.
Sorry to interrupt.
Sure.
The judge somebody changed a minute order at some point, and that was not on the record. We don't really know what happened underlying that.
Sure.
Is that correct?
Well, I can only go off what the record says. It appears that it was changed, but what I'll tell you that is consistent is that even in that original minute order, it says advised about probation revocation. And the opposing counsel's opening brief even says that. Let me see what the site is. I have it written down somewhere, but of course, now that it's written down, I can't find it. So even that first original complaint, in the first line of the minute order, it says initial advisement, probation revocation order, and then it continues on to say TRO advisement. So we don't know is the long and the short of it, but it doesn't impact anything here because we have that subsequent cure when the defendant pleaded guilty and was and the court assessed that plea as knowing, voluntary, and intelligent. So any deficiency in that initial advisement completely disappears as a matter of law. And that was my second point to your question. So I think I've answered both of those. This court and the Supreme Court have routinely held that substantial compliance with waiver rights and advisement rights is sufficient to convey the meaning of those rights. And there's no reason that would be any different here. And there's certainly no reason to augment any deficiency of advisement from essentially requiring a constitutional assessment to requiring a complete stripping of jurisdiction. There just simply is no case that I've ever seen that has done such a thing. I want to talk very quickly about the difference between an illegal sentence and a sentence imposed in an illegal manner before I get to the second question. And I see I'm doing okay on time, but if this court wants to prompt me, please do. An illegal manner question is an illegal sentence is one imposed outside of the bounds of statutory dictates, whereas an illegal manner question ignores essential procedural rights or ignores statutory considerations. Even assuming there was error here, and the people are certainly not conceding that there was any error or one that would have stripped jurisdiction from the court, there's nothing to suggest that this sentence was imposed in any sort of illegal manner because the only thing that was at issue is that statute, the probation revocation statute and the initial advisement statute, and the fact that the court might have failed to comply with the statutory considerations. But that is subject to the 120, now 126-day compliance period, which is far since elapsed. Turning to the second question, this court asked what's the status of the present need doctrine articulated in Moland and then as returned to in Wiedemer, and how does it apply to this case? And I would say that Moland is the first case that really identified it, but it explicitly declined to address the present need doctrine in terms of 17CA1503, which is the statutory time bar, and that's found in footnote 5 of Moland. And it says, we recognize that there's a present need here, but the parties have not briefed, and we are not going to address the interplay between the two, basically, or if there is one. Subsequently, Wiedemer, and even more importantly, Mershon, a year and a little bit later than Wiedemer, came along and basically said, it's the same. We're synthesizing it. The present need occurs from when the conviction enters. So in this case, when he pleaded guilty, it would have occurred in this case upon recognition of when that other case's murder conviction entered, because if it wasn't apparent then, it would never have been apparent. And it was certainly would have been present within those 3 years as required by 16.5402. In short, there's no reason that this claim could not have been timely brought within 3 years, because it's been apparent on its face, or would have been apparent on its face, well within that 16.5402 statutory time limit. The conviction itself always existed, as did the probation revocation complaint. And Mershon and a number of cases from this court, including Stevens and McPherson, come along and say that a subsequent event like the murder conviction does not trigger a renewed present need. Mershon is perhaps as explicit about stating that the present need exists at the time that the conviction enters. And I think that's about as clear a synthesis of 16.5402 with the present need doctrine as there is out there. I would note in preparing for argument that I found an interesting article in the Colorado Practice Series, which I know, Your Honor, you're quite familiar with. And it's in 15 Colorado Practice, Criminal Practice and Procedure, section 29.49. And there's a line in there that says this, talking about the Rule 35C requirement, the defendant must have a present need for relief. There's a statement in there that says this requirement is separate and distinct from the time limitations imposed by the collateral attack statutes, 16.5402. And I think that's maybe not correct at this point, because it's essentially assuming a subtle distinction that Mershon, I think, got rid of, or at least synthesized together to say that the statutes, as articulated by Fagerholm and then Wiedemer and then Mershon and then Stevens, all say that the present need doctrine is inherent within 16.5402, or else that statutory time limitation simply has no purpose.
Mr. Michaels, let me just ask you a hypothetical. It's not the facts of this case, but had a motion been filed within 3 years, but it was filed after a 1-year sentence was completely completed, would there still be, if there were mootness were raised, would a defendant need to raise present need?
I think they would want to. I don't know if they would have to, but I think it would be in the defendant's interest to explain why that present need was, why that present need still existed. Because otherwise, on its face, it becomes moot, and there's no way for the prosecution to understand what the practical impact is on it. And that's certainly something that I've dealt with on appeal. I just frankly didn't see that there was a practical need based on the contents of the opening brief. Do they have to plead it in order to get by? I think it's a close call. I really do. I want to talk very quickly about the defendant's actual plea in this case, because it's clear that the defendant did plead guilty to this, which and in order, part and parcel of that guilty plea is to ensure understanding of what is being pled to. And the minute order itself suggests that, in fact, it was to a probation revocation complaint. And that he essentially in a 35C hearing, in the previous 35C hearing, which again makes this one successive if in fact it's a 35C hearing, if this court determines, the defendant specifically acknowledged that he admitted to the probation violation, which is essentially saying, I understood that I was admitting to this probation violation. That's a transcript on March 5th, 2014 at page 68, 69. That's cited in my brief too. And I would just note, I think in conclusion, unless this court has any further questions, that there is a U.S. Supreme Court case that's dealt with this idea of present need in a somewhat analogous context, and that's Lane versus Williams, 455 U.S. 624, note 13 particularly. And it addresses this idea of consideration of a prior parole violation as whether or not it impacts a current parole and sentence and whether it's moot. And the Supreme Court held that it is in fact moot, because the idea is not that the prior parole violation should be disregarded or doesn't have an impact on the subsequent sentence, but because the parole violation should not be considered in subsequent parole determinations, because it is the defendant's responsibility to avoid violating further state laws, and that any subsequent violation that then results in an enhancement of that sentence based on the prior violation is something that the defendant could have prevented in the first place. And with that, I would simply say that this court should affirm the trial court's decision and find that it is successive and untimely.
Thank you, Mr. Michaels.
Thank you.
Ms. Trenery, you have 1 minute and 45 seconds left.
Okay, I'd like to just begin with the overarching concern that there was no mention of the 2004 case in the opening brief. The simple reason for that is that there was no discussion of it at the district court level. There's no mention of it in the district court order, and it simply wasn't raised, and that's why it's been waived. Really, the only thing that prompted the need to address that issue is the mootness arguments that appeared in the answer brief and sort of distinguishing between mootness and present need. As to the faulty advisements, Mr. Michael's position is that those have been analyzed based on constitutional rights. That's just not very accurate. In the Munoz case that I discussed, that was based on a violation of state law and the statutes and procedural rules. Similarly, the 2006 Helms case from this court, that was actually raised on direct appeal, and the court found plain error and based on a statutory error under 1611-2061. So it's not necessarily, hasn't consistently been just cabined to constitutional claims there. In terms of what Mr. Smith was actually advised of, there is a little bit of inconsistency in the initial minute order, the one that was changed. In the original minute order, it did say at the top, HADV RE probe revo. So I don't know what HADV is, but in the part that actually described the advisement, it says he was advised of a TRO. And then it was changed. And I do think that there is something to be read into the fact that it was changed and that it was done under the radar. I'm not sure what to make of that. Possibly that someone realized that the advisement was incorrect. And I do wish that we had the transcript to clear that up. But at this point, the evidence that we do have is Mr. Smith's testimony. Nothing contradicts that. He wasn't found incredible. And I think that we need to give that some credence.
And your time's up, Mr.
I see that. Thank you very much.
Thank you very much. Thank you both for your fine arguments. The case will stand submitted, and an opinion will issue in due course. We'll set up for the second case on the document now. Park Forest Care Center versus City of Westminster. And as I had mentioned earlier, I would circle back and ask if you had any questions or concerns about the process or the procedure. All right. Just as a reminder to the appellant, I know you were here for the first case. You have a chance for rebuttal, but it's really up to you to let us know that you want to reserve some time. All right? With that, we are ready to proceed. Second case. Park Forest Care versus City of Westminster, case number 2017CA1503.
May it please the court. I'm Assistant City Attorney Leslie Annand, Attorney Registration 22459. I'm here today representing the City of Westminster, Colorado, and its Finance Director, Tammy Hitchens. This is a case about whether Park Forest Care Center, a nursing home located in the City of Westminster, is liable for the city's use tax on meals that it purchased from a third-party meal provider and then served to its residents as part of their ongoing care. There are two issues on appeal in this case. First, does the city's use tax apply to the meals purchased by Park Forest? And second, who is the consumer for tax purposes? Based on the questions submitted by the court to the parties in last Friday's order, I'm going to focus on the first issue today. Does the city's use tax apply to the meals in this case? The city treats Park Forest the same as every other nursing home in the city, and that is we consider nursing homes to be service providers. And as such, they are deemed the user or consumer of all tangible personal property purchased and used in the provision of those services. The city assessed use tax in this case pursuant to two provisions of its code, Section 423B, which imposes use tax, and 425B1, which is titled Items and Transactions Subject to Use Tax. And I'm going to read that subsection 1 to you. It provides that the use tax shall apply to non-exempt tangible personal property purchased for use without payment of the sales tax and used, stored, or consumed inside the city, either personally or in conjunction with the rendering of a service. The first question posed by the court is, would the meals that Park Forest provides to its residents be subject to use tax under this subsection? And our response is, yes, it does. The meals in this case were non-exempt tangible personal property. Park Forest purchased these meals without payment of a sales tax, and Park Forest used these meals in conjunction with the rendering of a service. The controversy in this case arises because in these items that are listed subject to use tax, there's 5 items. Item number 4 provides that the city's use tax also applies to meals given without charge to employees or others. Now, Park Forest would like you to interpret this provision as singling out a very narrow category of meals to which the city's use tax applies. But in order to agree with that interpretation, you would have to nullify or have this section 4 trump this subsection 1, which illustrates the legislature's intent to broadly tax all tangible personal property that is non-exempt from taxation.
Let me ask you this, Ms. Anna. Why have a carve-out in section 4, subsection 4, that talks about meals if you intended for subsection 1 to include taxation on all meals?
Well, that actually gets to your question too. And what transactions is subsection 4 addressing meals targeted at? The plain language of this provision indicates that it's targeted to taxpayers who sell meals either on a retail or a wholesale basis. These might include restaurants, caterers, cafeteria owners, even the meal provider in this case who sold meals to Park Forest. This type of taxpayer, often in the course of business, will give meals to their employees. And this provision serves a clarifying purpose, Your Honor, of letting those taxpayers know that those meals are subject to the city's use tax.
But wouldn't all meals have covered that same point? I mean, right now, aren't we saying Part 1 means that meals are taxed, and that includes tangible personal property to include meals, and then Part 4 includes a subsection of meals sold to the public, or no, that's the other part of it. The other part of subsection 4 then, that talks about the cost of meals given without charge to employees or others, also is a taxable event. Why have 2 taxable events there when you could have said all meals are taxable, period?
Well, that's a good question, Your Honor, and we believe again that this provision is intended to provide clarification to taxpayers. And I think it's best understood when you look at all items subject to sales and use tax under the city's code. There are 15 items listed, the 5 under use tax and 10 under sales tax. And 6 of those provisions identify a specific category of tangible personal property that you could make the same argument that would otherwise be taxable under the general provision. But if you look carefully at each item and apply our interpretation, the city's interpretation, that these provisions are to be read in harmony and each one given effect, or Park Forest interpretation, which is a limiting interpretation, that these specific provisions are meant to limit a specific category of meal. If you apply that analysis to each of the 6 categories, and I've done this in my brief, that you will see that that interpretation leads to nonsensical results. It makes many provisions of the code superfluous.
Well, and along those lines, why doesn't Part 4 become superfluous if Part 1 is intended to include all meals by definition?
Well, Your Honor, it would not be considered superfluous if it serves a purpose. And the purpose that it serves is a clarifying purpose. And the rules of statutory construction provide that the only time a specific provision should be read to trump or nullify a general provision is if there's an irreconcilable conflict between the 2 provisions. There is no such conflict in this case. In fact, these provisions can be read in harmony. One must only accept that the city intends to tax all non-exempt tangible personal property as set forth in subsection 1, and we intend to apply our use tax to meals given without charge to employees or others. Park Forest's interpretation that this provision would carve out this limited category of meals given without charge to employees, and make them the only category of meals subject to the city's use tax is a nonsensical result, especially in light of the fact that the city is a jurisdiction that does not even exempt food from taxation, as many jurisdictions do. The provision is simply not superfluous if it serves a purpose. The better interpretation is to give effect to both provisions, that the city taxes all non-exempt tangible personal property, and it taxes meals given without charge to employees or others. The final and third question raised by the court is, what is the effect of the exemption provisions found in 427 on the interpretation of this meals provision? The city considers the exemption provisions significant for 2 reasons. Number 1, they show that when the city intends to exempt a category of tangible personal property from taxation, it does so explicitly. For example, cigarettes, prosthetic devices, prescription medications, farm implements are all exempted from the city's sales and use tax. Second, these exemptions also illustrate that when the city intends to exempt a class of meals from taxation, it also does that explicitly. In section 42627, the city exempts from taxation certain meals that are purchased with federal food stamps or SNAP funds. And this provision is also significant because if you accept Park Forest's interpretation that the city only imposes its use tax on this limited class of meals, then this provision becomes superfluous. And with that, Your Honor, I would like to save the remainder of my time for rebuttal.
Very good. You have 5 minutes and 47 seconds left.
Good afternoon. I'm Neil Pomerantz, bar number 24741, on behalf of the Appellee Park Forest Care Center. May it please the court. I'd like to begin, if I could, by spending just a couple minutes stepping back and talking broadly about the transactions involved in this case and how we view them for tax purposes. And then I'd like to immediately tie that context to the questions that were raised by the court last week. There were 2 transactions involving the subject meals. In the first, the company HSG, the source of the meals, prepared and sold the meals to Park Forest. It transferred the meals to Park Forest for consideration. That was a sale. Park Forest then sold those same meals to its residents. It transferred the meals to its residents for consideration. That was a second sale. The first sale from HSG to Park Forest was not taxable for a number of reasons, but first and foremost because it was a wholesale sale. And among the most fundamental principles in sales and use tax law is that only retail sales can be subject to a sales or a use tax. Wholesale sales are never subject to tax. There are no exceptions. And that's why the key use tax provision involved in this case applies the use tax only to meals that are given without charge. Because if Park Forest doesn't give those meals away, if it imposes a charge, which it did, then it purchased those meals for resale, and its own wholesale purchase of the meals can't be subject to tax. Put simply, Park Forest can't engage in a taxable use of a meal that it resells, much less tens of thousands of them each year. And a typical restaurant illustrates how this works. If a restaurant buys food and prepares a meal, and then it sells that meal to a customer, it has purchased the food in a wholesale transaction, and that purchase is not subject to tax. However, if the restaurant purchases food and prepares a meal and gives it without charge to an employee, or it comps it to a customer, then its own purchase of the food has become the final retail transaction, and that purchase can be subject to a sales or use tax.
You're describing what sounds like a sales tax.
Right, so if the first transaction, the purchase of the food by a restaurant in my example, becomes the retail transaction because the restaurant gives the food away, then either a sales tax could be imposed, which the vendor of the food would collect from the restaurant, or a use tax could be imposed upon the restaurant itself. They're complementary taxes. They apply to the same transaction, but it has to be a retail transaction. So Park Forest didn't comp these meals to anybody. They didn't give them away for free, and that's why its own purchase of the meals can't be subject to a sales tax or to a use tax. Now, the second sale from Park Forest to its residents also is not subject to the city's tax, and that's because the city's sales tax applies only to meals that are sold to employees or the public. And Park Forest didn't sell these meals to employees or to the public. That was the issue that was addressed in the Colorado College case and the BPOE Lodge case, which concluded that neither of those settings were public settings. The same conclusion would have to apply here as well. So we have 2 transactions, neither of which are subject to the city's sales or use tax, and there's nothing unusual about that result. Taxing jurisdictions commonly limit their tax on meals and food for a whole host of valid public policy reasons. So with that context, I'd like to turn now to the specific questions raised by the court. And the first question raised was, would the meals be subject to use tax under 4-2-5B1, the first subparagraph in the imposition section for the use tax? And our answer is no, for a number of reasons. The first is because that subpart begins by saying that the tax only applies to non-exempt tangible personal property. And these meals, when purchased by Park Forest, are exempt personal property. Why? Because if you look at the use tax exemption statute, 4-2-7, subpart 1 of that statute begins by saying we exempt from the use tax everything that's exempt from the sales tax. So essentially it incorporates all the sales tax exemption provisions. Those are found in 4-2-6. And if you look at subpart 16 of 4-2-6, you'll see an exemption for wholesale sales. These purchases of the meals, as I explained before, by Park Forest were wholesale purchases. And so that purchase is an exempt transaction. That's the first reason why B1 doesn't apply. The second reason why it doesn't apply is because it goes on to say that the property has to be purchased for use and used, stored, or consumed in the city. That is, the purchaser has to be the one that uses the property, has to be the one that uses, stores, or consumes. But Park Forest didn't use or consume these meals. It resold them to its residents. And so B1 doesn't apply to that situation. And the third reason why B1 doesn't apply is for the reasons that we spent a lot of time arguing in our brief, which is that we believe the operative provision for application of the use tax to meals is B4. And B4 says that use tax will only apply to meals when the meals are given without charge. And that didn't happen. And there's no dispute on that basic fact that these meals were not given by Park Forest to its residents without charge. And you can find evidence of that. Certainly the recitation of facts in the city's brief concedes that fact. You could find it in our complaint, paragraph 15, which said that Park Forest receives consideration for the meals. That was admitted by the city. You can find it in the admissions agreement, which I believe is Exhibit B to the Shamley affidavit, which states that charges for the meals are included in the daily rate. You can also find it on the invoices themselves, which I think is Exhibit E to the Shamley affidavit, which states a specific charge described as room and board. Okay. And I just want to say, I think you can look at all of these provisions or all of these reasons that I've described for why B1 does not apply as harmonious. They all really stand for the same basic proposition that purchases for wholesale, purchases for resale are not subject to the city's tax.
Mr. Pomerantz, why do we have subsection 4? Is it subsumed in subsection 1?
No, it's not subsumed. It really tells us the only situations in which a meal that is transferred can be subject to a use tax. The only situation where it will apply is if it's given without charge. If that provision didn't exist, then the answer would be basically all meals would be subject to tax. I'd like to turn to the second question that was raised by the court last week, and that is what types of transactions are subject to tax under 4-2-5B4, and I think this is your question. Let me try to answer it also by way of sort of, common examples. The restaurant example that I talked about is a situation that commonly comes up. If you go to a festival, perhaps, and they're giving away meals, it's saying that in that situation, the festival, like the restaurant, is not reselling the meal, therefore it is deemed to be the consumer of the meal and subject to use tax. To respond to a question that was raised with Ms. Anand, we certainly believe that if B4 was intended to serve only a clarifying purpose, number one, there's no evidence of that. There's no record evidence that the city council ever had that intent in mind. But it certainly wouldn't serve that purpose. There is nothing clarifying about a provision that says we only apply our use tax to a certain subcategory of meals if, in fact, they're trying to tax all meals. The simple way to do it would just be to say all meals are subject to tax. I think any reasonable party that reads that provision would walk away saying this describes the sum total of how the use tax is applied to meals. And to respond to a point that Ms. Anand made, it is not correct that other subparagraphs within that provision merely serve a clarifying purpose and not a limiting purpose. For example, if you look at the next sub-provision, B5, which talks about automotive vehicles, it tells us that the use tax applies only to automotive vehicles required to be registered at an address inside the city. And that's for obvious reasons why the tax would be limited to vehicles that are owned by city residents. If Ms. Anand's analysis were correct under that logic, then all vehicles would be subject to the city's tax if brought into the city, whether they're required to be registered here or not, whether they're owned by a resident of the city or not. The third question that was raised by the court in its questions last week was, what is the effect of section 4-2-7, which is the use tax exemption provision on 425B4? And our answer is that with any tax provision, with any tax code, you first look at the imposition provision to understand the initial reach or limits of the tax. And then you look further, once you've established those initial limits, to determine if any part of that presumptive tax is otherwise exempted in certain circumstances. So here, for example, if a meal is given without charge, it would presumptively be subject to tax under 425B4. But either the meal or the party that is giving away the meal might separately be exempted from tax under 427, which, as I mentioned, also incorporates the exemptions in 426. And let me give you an example of that. If you assume a situation where you have a charitable organization, under 4-2-6, subpart 5, I believe it is, sales to charitable organizations are exempted from the sales tax. That is incorporated into the use tax under the first subparagraph of 427, as I mentioned. So in other words, uses of meals by a charitable organization also would be exempt from tax. So if you imagine a situation where a food bank, for example, a charitable organization, gives away a meal to somebody who comes in, presumptively that would be subject to use tax under B4. It's given away without charge. But it is separately exempted from tax under 426 subpart 5, I believe it is, because it is now being given away by a charitable organization.
Mr. Pomerantz, sorry to interrupt, but let me see if I understand your position. 425B4, would you agree that, I guess then by implication, meals given free of charge to employees or others are subject to the sales use tax necessarily implies that other meals are not subject to the use tax?
Yes, and let me make sure I understand the question. So if the meal is truly given to an employee, or frankly, if it's given to anyone, but it's not otherwise exempted, then presumptively it would be subject to tax. The reason why that doesn't apply here, or it doesn't allow the tax, among other reasons, is that the meals weren't given away by Park Forest. Remember, this is a use tax assessment on Park Forest, and it's based upon the premise, at least under B4, that Park Forest gave those meals away without charge.
So we could say your reading of B4 implies that these meals are not covered
It doesn't
by
address
the use
these
tax provisions.
That's right. B4 does not address this situation, this fact pattern, because the meals are not given away. Which is another way of saying that the city, like virtually every other tax code in the country, does not tax purchases for resale.
So to follow up on my colleague's question, I guess, why would it not be a fair reading to say if, given B4, that you would have to increase by implication the converse with regard to all other meals as it concerns taxation, or not taxation in this case, because B4 taxes, and therefore you would imply that all other meals would not be taxed.
And forgive me if, you'll stop me if I'm not responsive to the question. Other meals are the only meals that are subject to tax in the hands of the purchaser, which is when a use tax would be imposed, is meals that are given away. And that's again because that transforms that party's purchase of the meals into a retail transaction. They become the retail consumer if they're just giving it away. A common situation that arises is a company that buys items and gives some away as samples. Those samples that are given away are subject to use tax because they've purchased the item in a retail transaction. But what this is telling us is that that is the only situation where a use tax would be applied to meals. Once you impose a charge for those meals, once the meals are in the hands of the purchaser and they turn around and transfer them to somebody else for a charge, then you have to look at that transaction to determine if it's subject to tax, because the prior purchase is now a wholesale transaction.
So, well, I see that your time's up, so I'm gonna go ahead and leave it there.
I guess the last point
Well,
I'm past the time.
yeah,
I'm
you're
sorry.
past your time.
Okay, thank you.
Thank you. Thank you both. Well, you still have an argument to go, a rebuttal. 5 minutes and 47 seconds worth. Sorry about that.
Your Honors, Park Forest continues to argue that it is a retail seller of meals to its patients. This goes to the second issue in this case. Who is the consumer of the meals for tax purposes? The city applies a use tax in this case because we consider Park Forest to be a user of the tangible personal property it purchases in the provision of services. This case can only be cited one way. Either Park Forest is a retailer or Park Forest is a service provider. And as a licensed nursing facility, as defined in the state of Colorado, it is clear that Park Forest is in the business to provide 24-hour per day, round-the-clock nursing care to its patients. This is a use tax case. This is not a sales tax case. Now, Park Forest alleges that if you interpret our use tax provisions in the way the city intends that it be interpreted, that we tax all meals. And that's exactly right. This legislative intent of our code to tax all non-exempt personal property is very clear. It is made clear in the definition of sales and use tax under the code. It is made clear in the imposition section under the code, and it is made clear in the first item under both sales and use tax, where it lists items subject to tax. We tax all non-exempt tangible personal property. These meals are not exempt. He would like to imply that they're not covered, but that goes against the legislative intent of our code.
And I'm glad you had the extra time because I was trying to ask a question about the exemptions from tax use, and maybe you can help clarify that. Is it your position that that what they are doing is asking for, well, no, B says the list of exemptions shall not be increased by implication or similarity. Do you believe in any way that that's being violated here?
Your Honor, Park Forest would argue that it's not implying an exemption, that it's arguing these meals are not subject to tax in the first place. So they're arguing that it doesn't come under the imposition section of our code, and therefore there's no need to exempt it. But we disagree. You cannot ignore section 425B1, which makes very clear that the meals in this case qualify as non-exempt tangible personal property on which a sales tax has not been paid and which Park Forest used in its provision of services. Now, Park Forest brought up the automobile example, and we actually think this is a good example because in singling out automotive vehicles under the code, again, we think this is a clarifying purpose. We get lots of questions from citizens about whether their vehicle is taxable or not. And this provision makes clear that if you purchase a vehicle—
Which provision? I'm sorry to interrupt, but
it was one that Park Forest brought up as an example. It's under 425B.
is it 5?
5, yes. So what it's clarifying here is that automotive vehicles required to be registered at an address inside the city on which the sales tax has not been paid are subject to use tax. Now, according to Park Forest, that would, if you take our interpretation, we intend to tax all vehicles. Well, yes, that's exactly what we intend, unless an exemption exists. And this is why this is such a good example. Because if you turn to the exemption section of the code, under 427A4, we explicitly exempt automotive vehicles that are used outside the city. This exemption, again, would be superfluous if you accept Park Forest's interpretation that these provisions of our code are meant as limiting provisions. We tax all meals in the city, except for meals purchased with federal food stamps and SNAP funds under certain situations. A court's job is to honor the legislative intent of the drafters. And the legislative intent is clear in this case that we intend to tax all non-exempt tangible personal property. The court is basically faced with two interpretations of the city's code that it must choose between. If you accept Park Forest's interpretation that the 6 provisions under 425B A and B addressing specific items of tangible personal property are intended as limiting the city's intent to subject all non-exempt tangible personal property to sales and use tax, then you are accepting an interpretation that creates conflict between the sections, that renders many of our exemptions superfluous, and that ends up with nonsensical results, such as we only tax meals that are given without charge. It's simply not the case, Your Honor. The better interpretation is to give effect to every provision and allow Section 42B1 to tax the meals in this case. Thank you.
Thank you very much. Thank you both for your outstanding arguments. I found them to be very helpful, and I'm sure my colleagues feel the same. The case will stand submitted, and an opinion will issue in due course. That concludes the court's docket for today. The court will now be in recess, and the bailiff shall so announce.